Let's talk a little bit about anticipatory breach. You want to talk about that?
Yes.
Because that gets asked all the time.
Yeah, so anticipatory breach, what is anticipatory breach? So anticipatory breach is a situation where one of the parties is unable to complete the transaction in advance. So something has come up and they realize they will not be able to close. So what we're seeing a common example of this to be is a buyer no longer having financing. Either the appraisal has come in low or they can't get financing anymore, and now they're in a situation where they can't close. Okay, so obviously the agents get involved, the lawyers get involved, and the biggest question we get asked is, well, what can my seller do now? Are we going to sit here? Can we relist? What do we have to do? So I think there's a misconception that in every situation you have to have a mutual release signed before the seller can move forward and relist the home. Okay, now this is obviously this will be very fact specific on the circumstance at hand, but generally speaking, a seller is not obligated to sign a mutual release in order to move forward once there's been anticipatory breach. And the reason is when we're acting for a seller where there's a breaching buyer, we don't want our clients to sign a mutual release. They are relinquishing then any rights they have to sue that buyer for any future damages. So if they sell for less, if they've signed a mutual release, they can't go back and sue buyer for that loss in sale price, plus all their other expenses that might stem from the breach. So we would be able to stick handle that situation then and put everybody on notice. We would write a letter to the buyer's lawyer and say, hey, your buyer is an anticipatory breach. Our seller is going to proceed with relisting the home, and any damages, they are reserving their right to sue, and then they can go ahead and relist the home. The seller has an obligation to mitigate their damages. And so what this means is the seller has to try their best to lower their damages as much as possible if they're going to go and make a subsequent claim against that buyer for a breach. So for example, let's just say we find out buyer's not able to close. This is on a Friday, we've talked about this, and then all of a sudden they relist the home on the weekend. The next day they get an offer that's substantially lower. Now, if the seller takes the first offer in hand, there could be an argument that they're not really mitigating their damages. They're not giving it enough time to see if they can actually try to make more money from the sale of the home. But if they give it a significant period of time, a few weeks, and they've conducted open houses and they've seen some offers, still can't sell for the same purchase price, it would be reasonable in that situation to accept that offer and then still be able to go ahead and sue for any further damages. The mutual release is required in terms of the brokerage, right? The brokerage can't release a deposit without the signed mutual release or a court order. But at law, a seller is not obligated to sign it. They're entitled to their damages, which would include any additional losses separate and apart from the deposit.